international law, and I could go on and on about this, but it's important to emphasize that indigenous people and the Chamorro people have important rights under international law. And these rights have a range of elements to them, but ultimately it's the right to control your own destiny and to have that autonomy that allows you to go forward in terms of your own values and your own tradition. Okay, so now I'm going to spend a couple of minutes on U.S. law to show that even though the United States, for various technical reasons, did oppose the Declaration, U.S. law is very consistent with these international law principles. And U.S. law has supported the rights of Native people, especially in recent years. So Native people were recognized as different in our Constitution right from the very beginning. In the U.S. Constitution, there are several references to Indians as separate and distinct people. This is the Commerce Clause. So all my students will remember this from constitutional law, because we spent a lot of time on it. And it says that Congress has the power to regulate commerce with the foreign nations and several states and with the Indian tribes. So the Indian tribes were seen as in the same category as states and foreign nations, as distinct entities. And then this is one of the provisions of the Constitution that was most contentious, because how were you going to count slaves for the purpose of apportionment? Finally, after much debate, they decided that the slaves would be counted as 3/5 of a white person. And obviously this is a matter of deep embarrassment to them. But even more interesting is that Indians weren't counted at all. So the Indians were even less involved in the polity than the slaves were. And so they were distinct. And the Pacific Islanders tend to feel awkward with the term Indian, but the Indians also don't like the term. Nobody likes the term. It was came about because Christopher Columbus got lost. He thought he was in India. He was in the Caribbean. So he called the people he ran across Indians, and the name sort of stuck, and all the European explorers used that term. And so Captain James Cook, when he came to Hawaii, when he came to Tahiti, and so on, he referred to all the people in the Pacific he saw as Indians, and you can see that in his journals and the journals of all the explorers. So it's just a term, it's an unfortunate term maybe, but it's a term that lawyers use to refer to Native people. And it's right there in our Constitution. And in the early years, John Marshall issued a series of opinions recognizing the autonomy of the Indians, of the Native people, and specifically ruled, for instance, that the state of Georgia could not enforce its law on the Indians, on Indian territory. So this is an important set of rulings. Of course, the United States then did terrible things to the Indians, and under Andrew Jackson and others, we had ethnic cleansing. We forced the Indians to relocate. The Trail of Tears and all these forced movements caused enormous suffering. And we mistreated the Indians, and for many decades, we entered into a period after the Civil War of assimilation. We were trying to sort of move the Indians into being sort of regular Americans. When Hawaii became into the United States, for instance, and Guam, this policy of assimilation took place. And so there's no separate treaty with the Native Hawaiians. But that all changed once again. So from 1865 up until for about 100 years, we had this policy of assimilation, but it started to change in the 1930s, 1940s, 1950s, and finally, in 1970, it changed in a very formal way when President Nixon issued a presidential statement saying that the Native people in the United States are entitled to a separate and distinct status and entitled to autonomy. So we reversed our policy completely. And since then, since 1970, the United States has done pretty well, and many Native people are now doing very well in the United States. The United States has a political relationship with 562 different Indian tribes or native groups. This map shows the Indian country in continental United States. And you see substantial parts of the West are Indian country, but also scattered around in the South, the upper Midwest, New York, New England, all over the United States, there is Indian country. These are areas where the native people control their land and govern themselves. And in Alaska, there's a separate law, but again, the native people have lands that they control, and they control themselves. And the U.S. Supreme Court has ruled that the special relationship of indigenous people is constitutional so long as provisions for the native people are rationally related to self-determination, self-sufficiency, and the maintenance of their tradition and their culture. In Hawaii, we're still working on these issues. The Native Hawaiians have never had a claims commission or a settlement, so they are still left out of this to some extent. But they have strong claims, and over time we hope that they'll have the same or a similar type of federal recognition that other Native people have. Right now, there's still considerable unhappiness among the Native people in Hawaii. Okay, so let's go back to Guam now and try to figure out what should we do here? How do we move from the status of no status to a status, a dignified status, an appropriate status, a self-governing status where the people of Guam control themselves and make their own decisions, and the Chamorro people of Guam have the rights of autonomy that other indigenous people have. So Guam is one of 5 U.S. flag islands. 3 of them are in the Pacific. 2 of them call themselves commonwealths, and I'm going to talk a little bit more about what a commonwealth is. Does it have any meaning at all? And then we have the 3 freely associated states as well, which I mentioned, and I'm going to talk a little bit more about them as well. Now, in a freely associated state situation, I mean, it's an association, obviously. It's free, which means that either side has the unilateral right to terminate the relationship and separate and go their own way. And so the mutual consent provisions of the Guam Draft Commonwealth Act are sort of like what a free association is, in the sense that each side has the right to sort of pick and choose. So in a typical free association situation, you have each side has the authority to modify the relationship unilaterally without asking the other side at all. You could just say, I'm out of here. Each side has complete self-governance. The larger country usually handles defense, and foreign policy is usually coordinated. So with the Federated States of Micronesia, Republic of Marshall Islands, and so on, the United States provides defense, and the United States does engage in discussions about foreign policy, and they are coordinated. But the FSM, the Marshall Islands, Palau, can enter into treaties without the U.S. permission. They can enter into regional organizations. They control their own ocean resources completely. So they have considerable autonomy within this relationship. And in addition to the 3 U.S. Freely associated states, we have other examples. The Cook Islands and Niue are freely associated with New Zealand. The Faroe Islands and Greenland have a free association relationship with Denmark. The Netherlands Antilles with the Netherlands. So there are a number of examples around the world, and each one is a little bit unique, but this is becoming an important type of relationship. So the Northern Marianas became a commonwealth in 1975 at the time that the Trust Territory islands were going through their self-determination process. But are they self-governing? They had a self-determination experience, but the deal they made with the United States did not make them self-governing, because they don't vote for the president. They don't have a voting representative in Congress. Congress can act laws that affect the Northern Marianas without any input any real input from the people of the Northern Marianas. So they are not self-governed.